Hi, I'm Dan Smith. Welcome to today's podcast episode of Business is More Exciting Than Any Game. Now, I'm doing 3 different series for this podcast. I did one just the other day in the first series, which is called Stronger Than Oak, and it deals with contracts and how entrepreneurs and small business owners can improve and have really great contracts for their businesses. The second series that I'm doing on Business is More Exciting Than Any Game, it deals with trademarks and how entrepreneurs and small business owners can protect their valuable intellectual property, their trademarks particularly. And this series is entitled Hands Off My Trademark. I'll do the third series here in a day or two, and I'll just kind of keep you in suspense as to what that series is about and what it's entitled. But today we're going to be doing Hands Off My Trademark. And for today's episode, I want to talk about one thing that sometimes small business owners and entrepreneurs may not know, which is they should know, and it can be very valuable to them in protecting their intellectual property. And that is, there are really 2 bases that you can file a trademark application under. One is called 1A and one is called 1B, and those pertain to sections of the Lanham Act, the Trademark Act, and the 1A is what you typically see, the basis for a trademark filing, 1A, which means that that trademark is already in use in commerce, and when you file your trademark application, you'll say, when was it first used in commerce, and you'll provide a date. And if your trademark application goes through to completion and you get a registered trademark, you'll have a date on your trademark file, your trademark certificate that basically provides that you have trademark protection from this date of first use in commerce. Now, another basis for filing a trademark, and this can be very valuable for small businesses that are being creative and thinking about what kind of goods or services they're going to be providing and how they're going to be marketing and branding those goods and services, but they haven't yet started using a particular brand, but they want to protect it. And so you can make a filing under Section 1B, which essentially is for intent to use trademarks. And what that means is you've got a trademark that you want to protect, but you haven't used it yet in commerce. So you can't file it under 1A because you're not already using it in commerce. So with a 1B or intent to use trademark application, you basically provide in your application what the trademark is that you wish to protect and indicate that you're filing it under 1B, intent to use, which means I'm not using it yet, but I intend to use it. And then when you make that kind of application, if it goes through, you won't get a trademark registration because you only get a trademark registration for trademarks that are in use in commerce. So what will happen if it goes through, you'll get a notice from the U.S. Patent and Trademark Office that your intent to use application has been approved, and it will give you 6 months to file a specimen of use showing that you are using the trademark in commerce. And once you file that and it's approved, then you can proceed to get your trademark registration. Now, sometimes a business files a trademark application under Section 1B, intent to use, and they're not ready in 6 months to file a specimen of use. Maybe they thought they would be using it in 6 months, but it hasn't happened yet. And they think, well, it may take another 6 months. You can get an extension on filing an intent to use trademark by notifying the IRS. That's for next time. By notifying the U.S. Patent and Trademark Office that you need an extension to file your specimen of use, you can do that and pay a small fee and get an extension, and then you'll have another 6 months. And you can make this extension request several times, but within the time that you have, you file your specimen of use. If it's approved, then you can proceed to get your trademark registration. So I bring this up to point out a very famous person who has just recently, within the last couple of weeks, filed some intent to use trademark applications. And that is the NFL football star Travis Kelce, whose company has filed for several intent to use trademark applications. One for his name, Travis Kelce, one for some Killa Trav, I think was one, and another one was All Right Nah. Some other, maybe there was one or two others that he is not presently using, or is not claiming he's presently using in interstate commerce, but that he intends to use in interstate commerce. Now, when you do your intent to use trademark application, you still need to provide what classification you're going to be using that trademark in. I think in this case, Travis Kelce had indicated that these trademarks were going to be used for bobbleheads and clothing, pins, things of that sort. And so he's planning ahead for his branding, getting names and slogans that he likes and thinks he can use in his business before he actually uses those trademarks in commerce. It's a great idea to do if you want to get ahead of the game, protect those trademarks before you use them, before someone else gets them. And so that is an intent to use trademark under Section 1B. All right, I hope that helps. If you have any questions, please feel free to reach out. And that's it for today's episode of Hands Off My Trademark, which is a series within the larger podcast, Business is More Exciting Than Any Game. We'll see you next time.